What is NY VTL 1192-3? Common Law DWI. You can be charged with DWI in New York even when there is no breathalyzer reading pointing to a specific blood alcohol level. New York Vehicle and Traffic Law Section 1192-3, known as Common Law DWI, makes it a crime to operate a motor vehicle while in an intoxicated condition, relying entirely on observable evidence rather than a chemical test number. Under the statute, prosecutors must prove that a driver consumed enough alcohol to be incapable of exercising the physical and mental abilities that a reasonable and prudent driver would need behind the wheel. This is what separates common law DWI from per se DWI under VTL 1192-2, which requires proof of a BAC at or above 0.08% through a chemical test. Because no specific number is required, the prosecution builds its case around the totality of circumstances, including how the vehicle was being driven, how the driver behaved during the stop, and everything the arresting officer documented. Officers are trained to record signs of intoxication from the moment they approach, noting things like an odor of alcohol, bloodshot eyes, slurred speech, fumbling with documents, and unsteady balance when stepping out of the vehicle. Standardized field sobriety tests, including the horizontal gaze nystagmus test, the walk and turn, and the one-leg stand, are also used, though their results can be challenged when officers fail to follow proper INCHITSA protocols, or when road conditions, lighting, or the driver's physical state affected performance. New York prosecutors can charge both VTL 1192-2 and VTL 1192-3 from the same arrest, giving themselves two separate theories of the case, so that if one line of evidence weakens, the other may still support a conviction. Common law DWI under VTL 1192-3 is an unclassified misdemeanor on a first offense, which means it carries up to 1 year in jail, fines between $500 and $1,000, a 6-month license revocation, and a permanent criminal record. A DWAI under VTL 1192-1, by contrast, is only a traffic infraction with a maximum of 15 days in jail, lower fines, a 90-day suspension, and no criminal record, which is why a negotiated reduction to DWAI can make a significant difference in a case. The license revocation that follows a misdemeanor DWI conviction is especially serious because it terminates driving privileges entirely, requiring the driver to reapply through the DMV after the revocation period ends, rather than simply waiting out a suspension. Attorney Randall F. Innis defends drivers facing VTL 1192-3 charges in Suffern and throughout the Hudson Valley, examining the traffic stop, officer observations, field sobriety testing, and chemical test issues that can shape how a common law DWI case is resolved. When you are facing a charge this serious, having a knowledgeable lawyer review the details of your case from the very beginning can affect every outcome that follows. Call the Innis firm, PLLC, the trusted law firm serving the Hudson Valley, at 845-533-0265, located at 400 Rella Boulevard, 165, Suffern, New York, 10901, to schedule your consultation with an attorney who will fight for your rights.